Hello everyone, I'm continuing with law, and this time it's rape, so not everybody's favourite topic. But anyway, so the Sexual Offences Act 2003, Section 1, it defines rape. Obviously, rape's been a crime for a century. Centuries, a millennium more than, but this clarified it. So it says 1. A person A commits an offence if A. He intentionally penetrates the vagina, anus, or mouth of another person. B. With his penis. B. As in B, that other person does not consent to the penetration. A, as in person A, does not reasonably believe that person B consents. 2. Whether a belief is reasonable is to be determined having regard to all the circumstances, including any steps A has taken to ascertain whether B consents. 3. Sections 75 and 76 apply to an offence under this section. 4. A person guilty under the offence is liable on conviction on indictment to imprisonment for life. Close quotation. Having said that, I don't know of anyone who ever got a life sentence or anything even close to it. Okay. So what behaviour constitutes rape? So one of the actus reus is this penile penetration of the mouth, rectum or vagina of another person, an unconsenting person. And remember, it must be with membrum virile. Digital insertion to the vagina, mouth, or anus, or putting in foreign bodies, that's not rape. That is a crime, though. So anyway, if an orifice is penetrated with a finger or another object without consent, then that's a sexual assault by penetration, as per Sexual Offences Act 2003, Section 2. In the mouth, it would be called sexual assault. Okay, so the Sexual Offences Act 2003, penetration is a continuing act from entry to withdrawal. So this goes back to this decision from Kaito-Maki 1985. So a man who continues to have intercourse with someone after she's withdrawn her consent is committing rape. So he begins having intercourse, that's fully consensual. Halfway through she changes her mind, saying no, stop, pull out, and he doesn't. That's turned into rape, even though the initial entry was not rape. So rape is a crime which can only be committed by a male. Note it can be committed against a male or a female. So the Criminal Justice and Public Order Act said it can be committed on a man or a woman. Yes, clarified that. So non-consensual penetrative vaginal, oral, or anal sex is rape. It doesn't matter whether the person ejaculates or not. That was laid out in R in the application of F against DPP 2003. Incidentally, vagina is now held to be an artificial vagina for transsexuals. So rape can be in marriage. Okay, the rape marital exception case decided that. Okay, so let's see if there is no consent. In most cases for the prosecution, the challenge here is demonstrating that there was no consent. So because human behaviour is variegated, these things take place in private. There are usually two people there. He said it wasn't rape, she says it was. Who are we to believe? Bree 2007 is a case about this. So prior to this act being passed, it was difficult to prove beyond reasonable doubt. And so people who alleged that they were victims of rape found this difficult, and they said they had to testify, they could be cross-examined by the person they said was their assailant. And so people say, oh, it's unfair to complainants, and now a defendant is not allowed to speak up in his own defence in terms of questioning her. He can't cite her sexual history or his sexual history. The complainant might have been an extremely promiscuous person, and if the jury was persuaded, they might say, well, it's hard to believe that such a person would have refused consent. You know, she did it with him, and him. Isn't it quite probable she did it with this guy as well, of her own free will? Anyway, so we don't have fair trials and in rape anymore, and the complainant's identity is kept anonymous for life, but that of the accused is splashed all over the front pages. So the Sexual Offences Act tried to deal with this and reduce the burden on the prosecution, so tilt things towards the prosecution. There are some conclusive presumptions under Section 76 and evidential presumptions under Section 75. So the victim is seldom questioned on the issue of consent. We think that go to the core of the whole offence. okay, it's presumed not to be there. So Section 75 and 76 are applicable where the prosecution have to prove the absence of consent. Usually they do that in relation to Section 74. So the prosecution usually is trying to show that the presumption doesn't apply, and as it's disapplied, then their task is a great deal easier. Okay, there are some presumptions, conclusive presumptions under Section 76, which are irrebuttable. They're evidential presumptions as per Section 75, and these can be rebutted by evincing evidence that despite the circumstances, the victim still consented. So what are the conclusive presumptions? It's presumed that both the victim did not consent and the defendant did not reasonably believe that she or he consented under certain circumstances. The prosecution tries to demonstrate beyond reasonable doubt these two circumstances, and if they manage to do so, then they win without having to prove anything else. So 2A, the defendant intentionally deceived the complainant as to the nature or purpose of the relevant act. B, the defendant intentionally induced the complainant to consent to the relevant act by impersonating a person known personally to the complainant. Close quotation. Those are both taken from the Sexual Offences Act. So Section 76 2A, before 2003, that was his first presumption. In Williams 1923, a singing teacher, he persuaded his pupil that intercourse was a breathing exercise to improve her singing voice. Well, I'm sure she sang out. Anyway, her consent was vitiated because he'd lied to her about the nature and quality of the act. So yes, what she was consenting to and what she was actually being done to were completely dissimilar. There's Lineker 1995, where a man was having intercourse with a prostitute, and then he didn't pay her in the end. Was that rape? No, it wasn't. She consented to intercourse, and she got intercourse. She just didn't get the money. Okay, but you could say, well, she didn't agree to his purpose. Anyway, at the time it wasn't rape. So, in G to 2007, the Court of Appeal said the presumption would be raised if there had to be stringent scrutiny here. Look at Section 76.2b. Prior to the 2003, if a man had intercourse with a woman, or indeed another man, by persuading this woman that he's her boyfriend, then that would be rape. So in one case, in Elba K, there were two identical twin brothers, and one of the brothers had a girlfriend. Then he goes away, so his twin comes along, and the twin persuades the girlfriend, "I am your boyfriend," and she had intercourse with him. Actually, it wasn't a boyfriend; it was the other twin who tricked her. So that would rape. So anyway, so consent is vitiated when the complainant's partner or spouse is being impersonated, but also anyone known personally to the complainant, right? What does known personally mean? You've met them once, or what? Do you know who they are? I don't think so. Just because as a celebrity, no, you don't know them personally. What is your Facebook friend? Never actually met them in person. Do you know them personally or not? That's a tricky question, and the courts have not yet settled it. Okay, so Section 76. This is about procedure. So the procedure here is that you've got to find if there's consent or not. And is it negatived by circumstance under Section 76? The prosecution will try to show that it is negative. And if they can't do so, they could say, well, there was no consent because of Section 74. And that's what happened in G to 2007. So the defendant began a sexual relationship with someone. Whenever she tried to end it, the defendant said, sent text messages saying from the police saying it's your duty to have intercourse with this person or you'll be fined. So the defendant was eventually arrested and said yes, he'd had intercourse with her. So the prosecution used Section 76.2a, saying that the woman was tricked for the nature and purpose of the act. The Court of Rules said that 76 would not apply here because the complainant had not been tricked as to the nature and purpose of the intercourse, but only to the situation that she was in. This didn't mean she was consenting. The prosecution had to do their job properly and show that there was no consent by pointing to Section 74, which they did. So the lying meant that the complainant hadn't exercised a free choice. We might say, wasn't she stupid enough to believe she could be fined for not copulating with this chap? But some people are stupid and they have rights too. We also want to defend them. Okay, so let's look at a number of evidential presumptions. There are 6 different circumstances, and there's a rebuttable evidential presumption that when the complainant didn't consent to the relevant act, the defendant did not believe the complainant had consented to the relevant act. The distinction between the presumptions in section 76 is the evidential presumptions can be rebutted by adducing certain evidence. This is difficult though. This is what it says. 3. The circumstances are that A. Any person who was, at the time of the relevant act or immediately before it began, using violence against the complainant or causing the complainant to fear immediate violence would be used against him. B. Any person who, at the relevant time or immediately before it began, causing the complainant to fear that violence was being used or that immediate violence would be used against another person. C. The complainant was and the defendant was not unlawfully detained at the time of the relevant act. D. The complainant was asleep or otherwise unconscious at the time of the relevant act. Okay, E. Because of the complainant's physical disability, the complainant would not have been able at the time of the relevant act to communicate to the defendant whether the complainant consented. F. Any person had administered or caused to be taken by the complainant without the complainant's consent a substance which, having regard to when it was administered or taken, was capable of causing or enabling the complainant to be stupefied or overpowered at the time of the relevant act. So that's the end of the quotation. So these are situations where it's improbable that the victim would have consented and that the defendant reasonably believed that the victim consented. Now, how about if you have intercourse with someone while she's asleep? Now, some couples do this and they're fine with it. You'd like to think they should wake up during it. Anyway, so this is the procedure that's followed. The prosecution has to show beyond reasonable doubt that certain circumstances existed. For instance, the victim was a kip when he entered her. Then you would assume that the victim didn't consent, and the defendant is thought to have known that. There's another evidential presumption where the defendant used force or the threat thereof to obtain intercourse. If you can prove this, then the prosecution will be able to win this, and they won't have to show the absence of consent unless the defendant can offer some very convincing evidence in rebuttal, or saying, for example, yes, we regularly did it whilst she was asleep and she was fine with that. If the defendant can prove all that, then the prosecution has lost. Okay. So section 75(2)(f), it looks at cases where there's date rape drug like Rohypnol is used, drinks are spiked or something like that. Section 75(2)(f) doesn't need that the victim is completely overpowered or a state of stupefaction by the substance. Only the substance could produce that effect. If the prosecution can demonstrate the substance was administered or caused to be taken, then the victim did not consent to copulation, and the defendant will be held to have no reasonable grounds for believing that she or he consented. But the defendant can rebut this presumption by citing some credible evidence that despite this trickery, the victim did freely and truly consent. Okay, let's look at the statutory definition of consent as per section 74. Here, the prosecution has to show that the victim did not consent. The presumptions are, the prosecution, I've explained the presumptions already, and that make the prosecution's task much easier. But the presumptions are not applicable. The prosecution has to show there was no consent by section 74, and that's as close as we get to a statutory definition. The whole concept was unclear before 1974, before 2004. What is consent? Is it enthusiasm, or is it reluctant agreement? So this was difficult. As Oleg Boja in 1982, the victim said, "I didn't consent, although I didn't struggle, I was terrified and could do nothing to resist." So the defendants said, "Well, I didn't threaten to use force on her, she consented." The Court of Appeal, they sidestepped that issue, and they left it to the jury. This is what Lord Justice Dunn said in that case. The dividing line between real consent on the one hand and mere submission on the other may not be easy to draw. Where it is drawn in a given case is for the jury to decide, applying their good sense, experience and knowledge of human nature and modern behaviour to all the relevant facts of the case. Close quotation. So Section 74 doesn't really help us. It shows consent, but in a very unclear way. A person consents if he chooses, has the freedom and capacity to make that choice. So what are freedom and capacity? Well, in a book on the Sexual Offences Act, this is what they said. Ideas which raise philosophical issues of complexity as to be ill-suited to the needs of criminal justice. Clearly these words do not reflect the total freedom of choice, so all things about how much liberty of action satisfies the definition remain at large. So Doyle 2010 was a case where this defendant raped his ex-girlfriend, and it was looked into by the Judicial Studies Board. So Judge Pill in the trial of Muhammad Zafar said the following: a female partner may not particularly want sexual intercourse on a particular occasion, but because as her husband or her partner is asking for it, she will consent to sexual intercourse. The fact that consent is given reluctantly or out of a sense of duty to her partner is still consent. Close quotation. So we've got a statutory definition of consent. Anyway, let's look at Kirk 2008. Here the Court of Appeal said that conviction was valid when a man, he said, well, I'll give you some money to this homeless person, money for food, if you have sex with me. She did, and he was convicted of rape. Seems grossly unfair to me. She could have said no, but she wasn't actually dying of starvation. He didn't force her. He didn't use threat of force. She wasn't forcibly imprisoned. She wasn't drunk. She wasn't drugged. But she could have begged off somebody else. Anyway, so the judge said, well, that was mere submission, which is not consent. In R against Ali and Ashraf, 2015, the Court of Appeal said that there was a rather childlike defendant had been groomed by the childlike complainant being groomed by the defendants. The evidence presented, the latter showed showed consent. The jury didn't have to accept that the consent was real. So how about intoxication consent? Bree 2007 is a case like this. So consent is tricky when there's alcohol involved, because can the person make a real choice? In Bree 2005, a man who was a blameless character, he consumed a lot of alcohol with a 19-year-old female. They had intercourse, and the prosecution case was that the complainant was drunk, but not so drunk that she couldn't consent. However, she didn't actually consent. She did not want to do it. Anyway, okay. So the trial judge didn't put it to the jury properly. The Court of Appeal overturned the conviction. Okay, so if alcohol makes the person unconscious or makes the alleged victim unable to know what's really happening, the victim doesn't have capacity to consent. Alcohol can prevent the victim from communicating their lack of consent. They don't have free choice. So how can you prove this? Because a lot of people have sex whilst they've consumed some alcohol. Okay, Dougal, in this case, it said drunken consent is still consent. In Kamke 2013, the Court of Appeal said that the direction was right in another case. This is a useful quotation. A woman can have the capacity to make a choice to engage in sexual activity, even when she's allowed to drink, obviously. Alcohol can make people less inhibited than they are when sober, and obviously everyone is free. We're all free to decide how much to drink and whether to have sex or not. However, if through drink a woman has temporarily lost her capacity to choose whether to have sexual intercourse or to engage in sexual activity of another sort, then she should not be consenting. Clearly, as I've said, a person who is unconscious through consumption of alcohol cannot give consent. And it may well be, therefore, a complete loss of consciousness, a state of incapacity to consent can be reached. So there are, of course, it's common sense again, various stages of consciousness are there not from being wide awake to having a dim awareness of reality. In a state of dim and drunken awareness, a person can be not in a condition to make choices. So we need to consider the evidence carefully in this case as to whether M state of consciousness or unconsciousness at the time of the penetration, and firstly decide was she in a condition in which she was capable of making a choice one way or the other. If you're sure that she was not, then obviously she was not consenting. If you conclude, however, that she was or may have been able to make that choice, you must decide whether she may or may have been consenting to sexual intercourse in relation to count 1, penetration of a vagina in relation to count 3, and the touching of the breast in relation to count 2. So there's also deception and consent, and that's if a person agrees to sexual activity due to a lie. That's not that's not as per section 75 or 76. What's informed consent? If someone has HIV positive and has intercourse with another, despite not telling the other person about this HIV status, is that the actus reus of rape? And that's unsafe sex, by the way. Presumptions do not apply. A has not lied about what they're doing, intercourse, so it doesn't vitiate consent. Okay. Anyway, the transmitter of a disease would be guilty under Section 20, though. So, in our Monarch against DPP 2018, a woman had intercourse, but her consent was not vitiated by the fraudulent representation that her boyfriend made, saying he was an environmental activist. In fact, he was an undercover policeman trying to infiltrate her group, which he did. The court said that she would not have consented if she knew his real job, but the judge ruled that didn't negative her consent under Section 76. Or, as in Gita, no other pressure is brought to bear. Some people say that's a strange decision and a wrong decision, because what happened to free choice? That's meant to be vital to consent. It seems to be discordant with cases like Kirk, Ali, and Ashraf. Okay, there are other things. Remember, you've got to agree by choice. In Assange 2011, a woman said she had intercourse with this man, but with a proviso that he had to use a prophylactic. Anyway, he didn't do that. But on the application of F against DPP, there was a similar decision. A man had to use a condom or not. Spunk into these were controversial decisions. The victim had consented to intercourse. There was no violation. Perhaps he should have been charged with common assault. They agreed to protected sex, but that's not what they got. Okay. So look at the procedure relation between sections 175 and 74. You've got to understand the procedure to follow. Anyway, so if you think a drink is spiked or there's an intoxicant used, you think, well, then the defendant's probably going to be convicted unless he can rebut the presumption that there was no real consent. He might be able to cite some believable evidence that despite her being under the influence of these substances, she consented, or he reasonably believed her to be consenting. So he will have to meet this evidential burden, saying that she said things which showed eagerness to copulate. If this evidence is regarded as credible, especially if the words or deeds of her are witnessed by others, the burden of proof is back onto the prosecution. They have to show that there was no consent. Anyway, with reference to Section 74, the prosecution will try to carry this burden of proof, and it's now returned to convince the jury the person who was intercourse with another got drunk, but not of her own free will, and didn't consent. There was no free choice on her part. Okay, tricky, hey. So the mens rea here is the person having intercourse, knowing the other person to be unconsenting or indifferent to whether there was consent. The belief which is not honest or based on reasonable grounds. That was set out in DPP against Morgan 1976. Honest belief in consent is only enough if it was based on reasonable grounds. Okay, so the judge can withdraw the issue from the jury if there isn't sufficient evidence. In Ciccarelli, the accused, he sexually assaulted the complainant whilst she was slumbering. The Section 75 presumption applied. She didn't consent as because she was unconscious, and the presumption was irrebuttable. The accused's defense was that he realized that she was asleep, but he believed that she would have consented had she been awake because she made a sexual advance on him earlier that evening. The trial judge in Section 75 said that whether or not he believed the accused were consenting, there wasn't enough evidence that the accused's belief was reasonable. The judge said she would direct the jury that way, so because of that, the accused changed to a guilty plea. He then was convicted. He appealed on the basis the judge's ruling was erroneous, and the court should have been permitted to consider whether his belief was reasonable. However, his appeal was denied. The Lord Chief Justice said this of the appellant's belief: either when she was asleep or in any other situations identified in Section 75(2), in what we describe as a position of disadvantage, will be considered by the jury provided there is evidence sufficient to raise that issue. Close quotation. So the Lord Justice agreed with the trial judge that there was no evidence that was reasonable. The reasonable person would lead a reasonable person to conclude the victim would consent. The parties scarcely knew each other. They'd never had any sexual contact. So you have to assess the reasonableness as per Section 1.2 of the Sexual Offences Act. having regard to all the circumstances, including any steps the defendant has taken to ascertain whether the person consents. So the person's belief is reasonable or not is something to be assessed objectively. It doesn't matter whether the defendant thought the belief was reasonable if it was not. In B 2013, the defendant obliged his partner to have intercourse here with him because he believed he had special powers, and this would prevent his partner taking an interest in other men. The court said this delusional beliefs would not, in law, render it reasonable. A belief his partner was consenting it when she wasn't. A delusional belief is an unreasonable belief. Okay, so that's enough about rape.